Hasmik Chinaryan was driving home from a family party with her teenage daughter and friend. Behind her, a Los Angeles Police Department officer was following. He recognized the vehicle as being the same make and model as one recently stolen in that area. He'd also run the plate, and it returned to a different vehicle. The officer was allowing other LAPD officers to gather before starting a high-risk stop. This week, I want to talk about Chinaryan versus the City of Los Angeles, a 2024 Ninth Circuit Court of Appeals case involving Fourth Amendment violations and high-risk stops. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona.
Call back for 86 negative.
Chinaryan was stopped and a high-risk stop began, involving almost a dozen officers and a helicopter. Everyone in the car was called out, one by one, and proned out on the ground before being detained. It was discovered that the car was not stolen and the plate was a DMV mix-up, with her vehicle and the other vehicle having only one digit difference in their VINs. Chinaryan sued the LAPD. One of the issues that came up, and the issue I'm going to focus on, is whether or not the officers were entitled to qualified immunity. In order for an officer to lose qualified immunity, two things must be met. First, the officers must have violated the constitutional rights of the person. And second, it must be clearly established that the officer's conduct violated those constitutional rights. The courts found that having reasonable suspicion alone that a car may be stolen is not enough to perform a high-risk stop. Now that's different from running a plate that comes back as a stolen car. Remember that in this case, the officers only had the same make and model, and a plate that returned to another vehicle. So, although there is certainly reasonable suspicion, the Ninth Circuit said that it is not enough to perform a high-risk stop, versus calling occupants out but falling short of forcing them down to the pavement at gunpoint. Because of these facts, the court felt that the officers used excessive force, and therefore violated the occupants' Fourth Amendment rights. So, as to the second part, whether or not it was clearly established that the conduct violated their constitutional rights, the court also said yes. They pointed to cases like Washington versus Lambert and Green versus the City and County of San Francisco as evidence that officers should have known that, quote, officers can be held liable for conducting a high-risk vehicle stop based on nothing more than a reasonable suspicion that the vehicle was stolen. So as a consequence, the officers were not, in this case, entitled to qualified immunity. This case is a strange one, and I personally fear that it may encourage officers to approach suspected stolen vehicles in an unsafe manner. So, with that in mind, it's important to note that the court also recognized three different stops common to the LAPD. One being a standard traffic stop, and the third being a full high-risk stop, but the second being somewhere in the middle. Calling passengers out one at a time, staying in a position of cover, having suspects show their waistline. Don't think that you are forced to sacrifice officer safety if you suspect a stolen vehicle. Be smart. If you have any questions or comments, please leave them in the comment section down below. Please remember to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos that come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.
Call back for 86 negative.